Your divorce can be won or lost during the discovery phase. In this episode, we'll discuss how to get the most out of it. Your spouse may be hiding important information from you. We need that information to protect your rights during your divorce. Without it, you're fighting your battle in the dark. Discovery is the way to get them to come clean and give us that information. We have several ways to get them to disclose their situation. Armed with this knowledge, you can continue your journey to your new life. What is discovery? Discovery is basically an exchange of information between you and your spouse. A lot of discovery is about your spouse's financial situation. In order to get you everything you deserve, we need to know about their income, assets, and debts, among other things. During a divorce, it's not unusual for someone to try to hide this information. They don't want you to know how much money they're earning, how much is in their bank account or 401k. That's because they're trying to keep you from getting everything that you deserve. That's why we have to stay on top of them and make them tell us. Mandatory discovery. Once a divorce is filed, both parties are required to provide certain information to the other. This includes tax returns, bank statements, and pay stubs. This is just the start of the discovery process. Once we get these documents, we'll sit down with you and analyze them to see what else we need. You'll be able to tell us if these records are accurate and if there's anything missing. We want to make sure we have a complete picture of their finances. Types of discovery. There are a number of different types of discovery. The most common are interrogatories, requests for production of documents, requests for admissions, and depositions. Each one of these techniques works in a different way. By using one or all of these methods, we're able to get a much better picture of your spouse's situation. By knowing that, we're in a better position to get you everything you're entitled to. Before we take a look at each method of discovery more closely, I just wanted to let you know that if you're considering divorce in Massachusetts, please visit affordlaw.org/checklist. We've put together a checklist and a free video mini course on the 7 most important things you should be thinking about before filing for divorce. Interrogatories. Interrogatories are written questions we send to your spouse. They must answer these questions in writing under oath. Because they are under oath, they swear that they are answering truthfully under the pains and penalties of perjury. That means if they lie, they could be charged with perjury. Also, if they are caught in a lie, they will ruin their credibility with the court. Interrogatories are often one of the first methods of discovery that we use. We're able to ask questions about a lot of things that are of interest. Once we get the answers, we have a better idea of what else to look for. Requests for production of documents. Requests for production of documents are sent to your spouse, who must then provide documents we're asking for. In mandatory discovery, we've already gotten a good deal of information about their finances. But very often, this is not a complete picture. We must dig deeper to uncover anything they didn't disclose or might be hiding. Besides documents, we can ask for any tangible items, such as electronic records or photographs. Requests for admissions. Requests for admissions are in writing and sent to your spouse. We're asking them to either admit or deny specific allegations. This is a very handy tool to limit the number of issues that are being litigated. If they admit to certain things, then we don't have to spend time and money proving them. For example, if they're working under the table and earning extra money that's not reported on their taxes, we would ask them, admit that you are working at ABC Corp. Admit that you earn $15 per hour. Admit that you work 10 hours per week, and so forth. Now we don't have to worry about finding other evidence to prove this extra income source. Depositions. Depositions are like a mini trial where there is only one witness. There is no judge present during a deposition. There are the lawyers, the parties, and the witness, as well as a court reporter. The witness is placed under oath and questioned by the attorney who called them. The witness can then be cross-examined by the other attorney. Everything is recorded just like at trial. Objections can be made by an attorney. Since there is no judge present, they can't rule on the objection, either sustained or overruled. But by objecting, the attorney preserves their right to have that objection heard if the transcript is going to be offered into evidence at trial. Depositions are stressful and expensive. They don't happen in every case, but they can be extremely useful. Discovery from third parties. The discovery techniques we've discussed so far are directed to your spouse. Sometimes a third party has important information that we want. In that case, we can subpoena that third party and request that information. For example, we can subpoena your spouse's bank or employer to provide us with financial information. Sometimes this is the best and most cost-effective method. Instead of arguing before a judge if your spouse objects to our requests, we can go right to the source and get that same information. Duty to supplement. Your spouse's obligation to provide information in discovery doesn't stop once they give us something the first time. They're under a duty to supplement that information as time goes by. For example, let's say that we ask them about all of their sources of income that they have. They respond by giving us their current employer. If later they get a new job, they have to update that information by telling us about that. Reciprocal discovery. Keep in mind that you're under the same obligation of discovery as your spouse is. If you have a contested divorce, you should expect to receive some or all of these discovery requests. That means that you'll have to answer interrogatories, produce documents, and even testify under oath at a deposition. There are many objections that we can make to help keep your information private. Lawyers often ask for more than they're entitled to. If you don't make the proper objection, you could be putting yourself in a bad position. For more information on Massachusetts divorce, please see our next video.